President.
The senator from Rhode Island.
Mr. President, I'm back today now for the 20th time to shed a little light on the dark money scheme to capture and control our Supreme Court. Part of what allows that scheme to flourish is the ethics-free zone around the Supreme Court. It's quite unique, so let's look at it. The last time I gave this speech, number 19, I walked through the various problems with how the Supreme Court handles allegations of misconduct by the justices. The short answer is that it doesn't. The United States Supreme Court is the only court in the country not covered by an ethics code, and worse than that, it's the only part of the federal government that has no process for ethics, investigation, and enforcement. None. Now, any meaningful ethics regime contains three things. First, a process for receiving complaints. Second, a process for investigating those complaints once they're received. And third, a process for reporting the result and holding powerful people accountable should those complaints turn out to be merited. The House and the Senate, for instance, we have our ethics committees. The executive branch has inspectors general and the attorney general. The federal courts, except the Supreme Court, have their own investigative procedures. It's just the Supreme Court that has none. The closest you get is probably a motion to recuse. Let's start with the difficulty of raising ethics complaints with the Supreme Court. People who are concerned about ethics violations over at the court have to get pretty creative because the court has no place to submit an ethics complaint. If you like, there's no inbox. We saw this play out when Judge Kavanaugh became Justice Kavanaugh. Multiple ethics complaints were pending against Judge Kavanaugh. The lower courts, like the D.C. Circuit that he was sitting on, do have a process for receiving complaints and for investigating them. And pursuant to that process, a special panel was appointed to review the complaints against Judge Kavanaugh. But as soon as Judge Kavanaugh squeaked onto the Supreme Court as Justice Kavanaugh, poof, the lower courts lost jurisdiction over him, and the complaints had to be dismissed mid-investigation. Now, the complaints could have been refiled up at the Supreme Court, but there was no place to file them. We saw the problem again when a man named Robert Schenck sent Chief Justice Roberts a letter explaining how he learned after a donor's private dinner with Justice Alito and his wife how the Supreme Court was going to rule in the Hobby Lobby decision. Apparently, a letter directly to the Chief Justice isn't a proper way to lodge a complaint because Schenck never heard back from the court. Months later, Schenck then went to the New York Times, which was following up on an earlier Politico story about Schenck's covert lobbying campaign to have wealthy right-wing donors invite some of the justices to meals, to their vacation homes, or to private clubs. It took the press, the Fourth Estate, to fill in the investigatory gap about that $30 million wining and dining campaign. More recently, a former co-worker of the Chief Justice's spouse alleged ethics problems with the Chief's failure to disclose financial connections between his spouse and parties and law firms appearing before the court, with no mechanism to ask the Supreme Court to review whether this arrangement presented a conflict. The former co-worker sent his complaint around to congressional offices in hopes that someone might take it seriously somewhere. Again, the complaint made it to the Fourth Estate, and again, without an inbox at the court or a process, it took journalists to give the inquiries an airing. Set aside the merits of these complaints. The point is, they never got in the door for the court's consideration. The court's refusal to receive ethics complaints is unique to the Supreme Court, and I submit it is not serving the institution well. So even if there were an inbox for an ethics complaint, the court still has no process to investigate it. Turn back to Mr. Schenck. After the New York Times reported on his allegation, there was understandable public uproar. Chairman Hank Johnson and I wrote to the court as court's subcommittee chairs to ask whether it was investigating the allegations. After months of silence, amid growing public clamor, the court did something it almost never does. It acknowledged the accusations. Through a 2-page letter from the court's legal counsel, which I ask unanimous consent to append as an exhibit at the conclusion of my remarks.
Without objection.
The court said the equivalent of, Justice Alito says he didn't leak the decision, and that's good enough for us. No mention in the letter of the lobbying campaign or of private wining and dining, and no description of anything resembling actual investigation. I've been the Attorney General of my state, a position that has criminal jurisdiction across the entire state. Only 3 attorneys general in the country have that. Rhode Island is one of them. I've been the United States Attorney for my state and led federal investigations. I know a little about investigations. It is Investigation 101 to take statements from witnesses. That's how you make a record, and that's how you deter lying, by tying people to a statement so they can be held accountable if it turns out that the statement is false. No sign in the letter that that was done. Same again with Justice Thomas regarding his refusal to recuse himself from cases implicating his wife's efforts at overturning the 2020 election. Back in January 2022, Justice Thomas participated as the lone dissenter in a decision that allowed the House January 6th Select Committee access to records from the Trump White House. And a couple of months later, it turned out that Justice Thomas's wife had texted with White House officials repeatedly about overturning the 2020 election. So she was clearly covered by that investigative effort by the January 6th Commission. He did not recuse, and indirectly it was suggested that Justice Thomas knew nothing at all about his wife's activities, so he didn't need to recuse. Okay, but that's a fact question. What did Justice Thomas know about his wife's activities at the time of the case? Easy to ask him. Easy to take a statement from him. But no sign that that was done. So, of course, no statement and no consequences. Later, after the reporting about Justice Thomas's wife's activities came out in the public press, and he failed to recuse himself in another case, The issue is no longer just a fact question about what Justice Thomas knew. He was now on notice about his wife's conduct, and he still did not recuse. Why not? Again, no justification, no investigation, no conclusion. The court has repeatedly failed to investigate or even acknowledge this glaring problem. Which brings us to the third element of an effective ethics regime: accountability and transparency, a report at the end. An investigation ought to be designed to get to the truth and to report its findings so that people can be held accountable for wrongdoing and the public can have confidence in the outcome. That is a statement so obvious, I find it hard to believe I actually have to say it here about the court. The one investigation we have seen the Supreme Court undertake was done in response to the Alito draft opinion leak. As an investigation, it was pitiful and marred with conflicts. My surmise is that in the heat of the court's ire about the leak, the assumption was made that some clerk or staffer was responsible. Chief Justice Roberts directed the marshal of the court to investigate. He called the leak a singular and egregious breach of trust that is an affront to the court and the community of public servants who work here, end quote. Well, for more than 8 months, the public waited to find out whether the marshal's investigation would live up to the Chief Justice's words. In the end, the court's handling of the Dobbs investigation was a case study in how not to conduct a fair and transparent investigation. The problems were numerous, not least that the marshal of the court isn't normally responsible for leading investigations. But the problem that really emerged was that some of the prime suspects for the leak were her bosses. And the investigation held the justices to a different standard than everyone else at the court. Everyone else at the court had to sit down for formal interviews, had to turn over their private communications, had to sign affidavits under oath. But when it came to the justices, it was different. They were subject to something that the court called an, quote, iterative process, end quote. I have no idea what an iterative process is. I can tell you what it isn't. It isn't an investigative process. The justices even asked questions of their own, some statement. The premise seems to be that even here, the justices can never be investigated. This was going to be a tough, fierce investigation as long as it looked like it was going to be clerks and staff. But once it looked like it might be justices involved in the leak, suddenly the wheels fell off. I've never seen an investigation where the investigator called in a third party to provide public assurance that they did a good job. Like a little sidecar running next to the investigation. Yeah, they're doing a good job. In this case, worse, it was a third party with conflicts of interest, with relationships with obvious suspects, and with contracts with the court. So if you compare all of that to how misconduct investigations are handled everywhere else in the federal government, you see some pretty big discrepancies. In the executive branch, Congress has established inspectors general who are surrounded by professional staff experienced in internal investigations. IGs know how to conduct real interviews and record witness statements. Congress has its own internal procedures and investigators for ethics complaints. We have our ethics committee. The House has its ethics committee. Congress set up procedures for ethics investigations in the lower courts. They exist. Judges are investigated, and people can know where you submit your complaint and how that complaint gets investigated. The Supreme Court is unique across the entire federal government in being impenetrable to investigation. From no ethics inbox, to no process for reviewing a complaint, to no credible report at the end of the day. The highest court in the land should not be held to the lowest standards in government. So last week, Congressman Hank Johnson and I, joined by Senator Blumenthal and Congressman Nadler, Quigley, and Cicilline, reintroduced our Supreme Court Ethics Recusal and Transparency Act. Our bill would finally require the Supreme Court to have not just a code of conduct, but a real process to enforce that code and other federal ethics laws. Our bill would also update judicial ethics laws, ending the ability of judges to ignore conflicts of interest and their recusal obligations, requiring justices of the Supreme Court to disclose gifts and travel as other federal officials do, and exposing the real interests appearing at the court behind amici curiae who lobby the court under fake names. Apparently, there has been a half-hearted effort at the court to begin to deal with this. The Washington Post reported last week that the justices discussed for years a binding code of ethics, to no result. And the effort seems to have fallen apart. So that leaves Congress in the position that if they won't fix it, we will. There are many problems plaguing our Supreme Court. Far-right dark money interests spent years stacking the court with their hand-picked justices, who in turn have delivered for those interests at every available opportunity. We need to undo the damage wrought by the court that dark money built and by those who built it. But we can start by bringing basic standards of integrity to the Supreme Court, standards all other judges follow, and standards that govern all high-ranking federal officials across all three branches of government, officials who are paid by taxpayers to serve the best interests of the American people. Mr. President, to be continued. I yield the floor.
Mr.
President.
Senator from Rhode Island.
Is the Senate presently in a quorum call?
No, we are not. The senator is recognized.
Then I may proceed. Terrific. Thank you. I'm here for now the 21st in my series of speeches about the scheme to capture and control our Supreme Court, a scheme to which right-wing special interests have devoted hundreds of millions of dark money dollars. The ingredients in this noxious cocktail are creepy right-wing billionaires, phony front groups, amenable justices, large sums of money, and secrecy. This month, we've gotten a whole new look at how these ingredients mix. According to extraordinary reporting by ProPublica, for more than 20 years, Justice Clarence Thomas has accepted luxury trips virtually every year from billionaire Harlan Crow without disclosing them. Here's how ProPublica described it. Thomas has vacationed on Crow's super yacht around the globe. He flies on Crow's Bombardier Global 5000 jet. He has gone with Crow to the Bohemian Grove, the exclusive California all-male retreat, and to Crow's sprawling ranch in East Texas, and Thomas typically spends about a week every summer at Crow's private resort in the Adirondacks. Close quote. One of those trips Mr. President, has been valued at more than $500,000. We've heard from civil servants who have to report a gift of $5. This justice received a gift of a trip that they valued at $500,000. It was a trip to Indonesia on Crow's private jet, followed by, and I quote here, 9 days of island hopping on a super yacht staffed by a coterie of attendants and a private chef. And that's just one excursion. No telling how many others there were. None of this was disclosed. The supposed rationale was that it was all personal hospitality. So let's set aside for 1 second the question whether this actually was personal hospitality. Let's presume that there was personal hospitality here somewhere. What that overlooks is the problem of the personal hospitality exemption, which covers exemption from disclosure of food, lodging, or entertainment received as personal hospitality of an individual. Food, lodging, or entertainment, not transportation, not travel, not trips on Harlan Crow's private jet. ProPublica was able to identify multiple trips that Thomas took on Crow's jet, and each one of those trips seems to be a slam dunk violation of this provision. Not food, not lodging, not entertainment, transportation. It does not stop there. Additional reporting by ProPublica revealed more of Crow's undisclosed generosity. In 2014, Crow purchased from Thomas and his relatives 3 properties in Georgia, including the home where Thomas's mother lives. There seemed to be more collateral gifts in the form of renovations and an agreement that Thomas's mother would live there rent-free for the rest of her life. There's much more to learn about all of this transaction, but back to the disclosure. Here's what the law requires for property disclosures. It requires the disclosure of any purchase, sale, or exchange during the preceding calendar year which exceeds $1,000 in real property other than the property used solely as a personal residence of the reporting individual. If it's not your home, if it's any other real property, and if it's worth more than $1,000, the law requires that it be reported. Thomas disclosed none of this on the annual disclosure forms required by law. This law applies across the government. This isn't something special for the Supreme Court, but transparency is especially important for judges, who must recuse themselves from cases if there's even an appearance of impropriety. Purchasing Thomas's property and offering him free international vacations weren't the only favors bestowed by the billionaire. In 2011, the New York Times reported on him having, quote, done many favors for the justice and his wife, including using his company to finance what the Times called the multi-million-dollar purchase and restoration of a property where Justice Thomas's mother used to work, donating $175,000 to a Savannah library project dedicated to Justice Thomas, giving Justice Thomas a $19,000 Bible that belonged to Frederick Douglass, and providing $500,000 for Ginny Thomas, his spouse, to start a Tea Party-related group. End quote. Well, could any of that raise an appearance of impropriety? Or was it purely personal, nothing to do with the court? Well, let's have a look at a picture that shows us a little illumination of that. This is a painting that Harlan Crow commissioned during one of Thomas's visits to Crow's private lakeside Adirondack retreat. On the right here is Crow himself. Next to him is Justice Thomas. Crow sits on the board of two conservative organizations that file briefs before the Supreme Court. Crow is also a donor to the Federalist Society, from which Trump's infamous Supreme Court list emerged. And by the way, dark money surged into the Federalist Society during that period. Crow is also a political donor to Republican politicians. Investigation would show whether all this amounted to enough business before the court to create a conflict of interest. But the Supreme Court won't permit any investigation of its members. Here on the left is the infamous Leonard Leo, the man behind that Trump Supreme Court list, whose 3 new justices created the far-right supermajority that Justice Thomas now enjoys. Leo's front group, the Judicial Crisis Network, bought the campaign ads for the 3 justices, paid for with dark money. Here's a graphic I've used before showing Leonard Leo's flotilla of front groups that he uses. He has more. This is just one assortment of his front groups. Here's the Judicial Crisis Network, which took checks as big as $17 million from anonymous donors and used that money to spend on ads for the confirmation of the 3 new justices. Leo is the one who helped the right-wing billionaires knock out Harriet Miers. Do you remember when she was a nominee for the Supreme Court by a Republican president? Knocked her out to make room for none other than Sam Alito to get onto the court. The campaign that Leo oversaw by the billionaires to capture the court has been tallied at more than $580 million. $580 million, much of it dark money. And he recently received from another creepy right-wing billionaire a $1.6 billion slush fund into yet another 501c4 front group. So it is deeply misleading to claim that Justice Thomas never vacationed with people that had business before the court. Leonard Leo's business is the court. The creepy billionaire's campaign was to capture the court. Leo was the billionaire's contractor for construction of the court that dark money built. Personal hospitality. After Thomas gets on the court, a major Republican donor befriends him with $500,000 for his spouse's activist group, a renovated home for his mother, and lavish undisclosed vacations, at which Thomas was sometimes accompanied by right-wing activists at the center of the scheme to capture the court. And we're supposed to believe this is all legit? I don't think so. And guess who else doesn't think so? Justice Thomas, who knew this smelled enough that he broke the disclosure law repeatedly to keep it secret. Guess who else doesn't think so? Ask other federal judges. They can't get away with this personal hospitality nonsense. They know this is wrong and that it's embarrassing to the judiciary. That's why the Judicial Conference just cracked down on the personal hospitality shenanigans of their Supreme Court colleagues. Thomas is feeling enough heat that he even released a public statement. Early in my tenure at the court, he said, I sought guidance from my colleagues and others in the judiciary and was advised that this sort of personal hospitality was not reportable, and that he has always sought to comply with the disclosure guidelines. Wow, where to begin? First, who advised Thomas that this personal hospitality was not reportable? Whoever it was, they were wrong. I've spoken before about this personal hospitality issue. The reporting exemption for personal hospitality covers ordinary gifts of food, lodging, and entertainment from friends and family. There is not an exemption for transportation, for all that flying around the world in private jets. It just isn't there. We don't know who advised him, but I can pretty surely tell you who didn't advise him. That's the formal committees of the Judicial Conference that advise on ethics and financial disclosure issues. They have committees for this. That would be the obvious place to go for real advice, yet all indications are that he did not. I suspect that Thomas knew that they would not like the facts that he would have to disclose if he were to ask them in candor to offer an opinion on his situation. And he also, I suspect, knew that he would not like the answer that he would get. So he just didn't file. The recent definition of personal hospitality that the Judicial Conference announced in response to 2 years of urging from me was intended to clarify what was already prohibited, a clarification that every other branch had already issued. And the reporting law never exempted private jet travel. Thomas actually knew this because he had reported flying on Crow's private jet before, back in 1997. What changed? Federal law is crystal clear on the need to report real estate transactions worth over $1,000. The law is so clear that CNN reported yesterday that Thomas will amend his disclosure report to include that sale. According to what CNN called a source close to Thomas, Thomas has always filled out his forms with the help of his aides, and he didn't think he needed to report the sale because he didn't make any money off it. Well, that excuse might be believable if the statutory language weren't so clear, crystal clear. And if Thomas weren't what one commentator has called a repeat offender at disclosure. In 2011, Thomas had to amend 13 years' worth of financial disclosure reports to add his wife's income from the Heritage Foundation, a dark money conservative outfit which also files amicus briefs at the Supreme Court. He said it was a misunderstanding. Here's what he misunderstood. Financial disclosure report form. B, spouse's non-investment income. If you were married during any portion of the reporting year, complete this section. Income, none, or date and source. That is not complicated. Those instructions are simple. And like his private jet travel, Justice Thomas had reported his wife's income before, back in 1996. What changed? Congressman Hank Johnson and I sent a bicameral letter to Chief Justice Roberts urging him to get his courthouse in order and set up a means to investigate these and other serious allegations of misconduct. We have also sent a letter to the Judicial Conference calling for the conference to refer Justice Thomas to the Attorney General for failure to report his real estate transaction with Crow. Here's how that works under the ethics law. The head of each agency or the Judicial Conference shall refer to the Attorney General the name of any individual which such official or committee has reasonable cause to believe has willfully failed to file a report or has willfully falsified or willfully failed to file information required to be reported. The Attorney General, in turn, may bring a civil action against any individual who knowingly and willfully fails to file or report any information that such individual is required to report. That is not complicated. And the Supreme Court is completely alone here in its peculiar approach to these issues. Wherever else you go in government, you will find an ethics code, and you will find a process for investigating and enforcing the ethics rules. Congress has ethics committees. The executive branch has an ethics office and inspectors general. Federal courts have their own ethics process. Only the Supreme Court has none of that. No designated place to submit complaints. No investigative mechanism to review complaints. No impartial panel to decide complaints. No transparency. All of that needs to change if we are to rebuild confidence in our highest court. Without investigation, it's impossible to determine if Justice Thomas violated still another federal law by participating in cases implicating his wife's political activities. We need investigation to find out whether he broke that law. Without investigation, there's no way to evaluate the ethics of the 20-year, $30 million private judicial lobbying campaign run by right-wing political activists who wined and dined Justices Thomas, Alito, and Scalia, the three justices who, as the New York Times described it, proved amenable. Amenable. Without any prospect of investigation, there's little reason for a justice to comply with the ethics standards. When there's no ref, there's ultimately no rules. The rule that clearly pertains is that it's not okay to judge one's own case. That rule is so obvious I hardly need to state it, and that rule is so old it's in Latin. Nemo judex in sua causa. No one should be judged in their own case. We know that Justice Thomas is familiar with this rule because he cited it in an opinion he wrote just a few years ago when he noted that at common law, a fair tribunal meant that no man shall be a judge in his own case, end quote. This good old rule, grounded in history and tradition, the present Supreme Court constantly and flagrantly flouts. That must stop. The justices have lost the benefit of the doubt. 240 years the court went without needing this. But this Roberts Court has squandered the public's confidence with its behavior, and now there must be rules and process. The Senate Judiciary Committee, along with my subcommittee, will hold a hearing to consider these issues. I hope our colleagues will take it seriously. Congressman Hank Johnson and I have introduced the Supreme Court Ethics, Transparency, and Recusal Act, which would solve a lot of this mess, this big, tragic, unnecessary, self-inflicted mess. Let me conclude where I began, with that noxious cocktail of creepy right-wing billionaires, phony front groups, amenable justices, large sums of money, and secrecy. It's a toxic brew. The ethics failures at the court are just one part of that stinking cocktail. We have justices picked in some back room at the Federalist Society by creepy billionaires to put on a list for Donald Trump. We have justices who came through a confirmation process so tainted with influence that the FBI was breaking its own procedures in background investigations. And senators were pulling screeching 180s on confirming Supreme Court justices in an election year. Flotillas of front group amici curiae, who won't tell who orchestrates and funds them, appear in court to tell those justices what to do. And the justices, with astonishing statistical reliability, do as they are told. To get the results they want, the justices smash through precedent, violate so-called conservative judicial principles, make up false facts, and change the applicable legal standards. All of this mess, all of it, is the product of that toxic brew of creepy right-wing billionaires, phony front groups, amenable justices, large sums of money, and secrecy. For now, let's at least fix the ethics mess and bring the Supreme Court into alignment with the rest of the federal courts. The highest court should not have the lowest standards. To be continued, Mr. President, I yield the floor. To the witnesses, one of the things I noticed about the Dobbs decision was that in order to get where the justices in favor of that decision wanted to go, they had to change the legal standard from a balancing of interests to history and tradition. In a balancing of interests, one of the interests is the interest of the woman involved in the procedure. In history and tradition, you go back to ancient history, before women had rights, like the right to vote, like the right to have credit without the permission of their husband. It looked like the rights of women were being deliberately removed from the equation by the justices of the Supreme Court. And in that context, Ms. Zarowski, how did it feel to you? How did you feel that your rights, your interests were being considered as you went through the experience that you had to?
I felt I had absolutely no right to make a decision for my own body, for my own health, for the health of my child. I thought about when my grandfather was in the hospital, similarly also had sepsis, and my dad and his siblings were making the decision on how he should receive healthcare and what kind of treatment he should receive. And what I couldn't understand in those 3 days where I had to sit and wait to get healthcare is how is it that my dad was able to make healthcare decisions for his dad, but I couldn't make my own healthcare decisions for myself and for the child that was inside me. I had no right, I had no opportunity, and neither did my healthcare team.
In addition to changing the legal standard to get the result they wanted, the other thing that stuck out for me in that decision was Justice Alito's language that Roe versus Wade, and I'll quote him here, was egregiously wrong from the start. So presumably that means the start back in 1973. Well, after that start, while Roe was egregiously wrong, Alito came before this committee. And he had the chance to tell us that he thought Roe was egregiously wrong, make that observation about that case, and instead he hid that sentiment. He said instead, Roe versus Wade is an important precedent of the Supreme Court. It was decided in 1973, so it has been on the books for a long time. It is a precedent that has been on the books for several decades. It has been challenged. It has been reaffirmed. No egregiously wrong. Everything designed to reassure us that he was not going to overturn that decision. So looking back, he looks a lot like a sleeper agent predetermined to attack Roe, who wouldn't disclose what he was up to until he had the majority that he needed to change the legal standard and destroy the legal precedent. I think it's a very unfortunate episode in the Supreme Court's history. Dr. Verma, one of the groups I've heard the most from about this in Rhode Island has been OBGYN doctors who express real horror at what this means for their practice, particularly in circumstances where a pregnancy has begun to go wrong, where there are very difficult decisions that have to be made that balance the life of one fetus against perhaps another if it's twins, against risk to the mother. And in that context, they view these laws as forcing decisions and disabling them from making decisions that are customary medical practice. Could you comment on that and what some of the circumstances are that you consider to be most dangerous with regard to these laws?
Absolutely. Thank you for that question. I can tell you as the OBGYN on this panel who provides full spectrum care, including labor and delivery and abortion care, that these laws are creating huge amounts of confusion on the ground and preventing people from accessing the health care that they need. We train for years and years to be able to look at the person in front of us and to make the best healthcare decisions with them and their families. And we're seeing that many people with high-risk pregnancies are not able to get the abortion care that they need. You've heard a couple examples of people that break their water before the baby's able to survive outside of them. I also take care of people with medical conditions like really high blood pressure, where continuing the pregnancy puts them at risk for things like stroke and preeclampsia. We see people with peripartum cardiomyopathy, where the pregnancy causes their heart to enlarge and weaken, and the risk of having that happen again in another pregnancy is quite high. For all of these people, we're having to ask ourselves, how sick do they have to get to be able to intervene? Instead of just being able to provide the best medical care for the person in front of us, we're having to figure out, can I do this under the law? And that's creating huge amounts of confusion and absolutely preventing people from getting the care that they need.
Thanks, Mr. Chairman. I'd like to ask unanimous consent to let statements from some of Rhode Island's OBGYN doctors be admitted into the record.
Without objection. 11 years ago to the court was certainly not any indication of current feelings about court opinions. Another person who's been on this subject for many years is the chairman of the court subcommittee, Sheldon Whitehouse of Rhode Island. I recognize him now.
Thank you, Chairman. We are here today because the Supreme Court is playing out of bounds of the ethics rules for federal judges. Justices read the ethics rules in unique and eccentric ways, and when they're caught out of bounds, they refuse to allow any investigation of the facts. The personal hospitality problems I've been pursuing began with Justice Scalia, who took more than 7 dozen undisclosed hunting vacations. Most people know of 2, the one where he was on the Air Force II manifest with Dick Cheney, and the one where he died. There were 70 plus more. It was systematized. Some intermediary would ask the owner of an expensive resort, often a commercial property, to extend to Scalia a personal invitation to the resort. Even where the owner was someone he'd never met, Scalia treated as personal hospitality because of the personal invitation and failed to disclose the vacations. Gun industry advocates, fossil fuel folks, and Republican political figures often tagged along. No reasonable reading of the term personal hospitality would cover this, but the Supreme Court let this go on for years. When I challenged the court about this practice, Exhibit 1, I got a blow-off letter. Exhibit 2. Basically, nothing to see here. So then I asked the circuit courts what they thought about this conduct. I went 0 for 13 on answers. Oh, that would be Exhibit 3. I went 0 for 13 on answers, so I then sent another letter saying I hope their silence didn't indicate some kind of coordinated obstruction. Exhibit 4. I also scheduled a subcommittee hearing. Presto, I was told the Financial Disclosure Committee would examine how the exemption was interpreted. That's Exhibit 5. Almost a year later, 2 weeks before the recent news about Justice Thomas broke, the Judicial Conference updated its guidance to clarify that this sort of non-disclosure violates the law, Exhibit 6. I have no evidence that any federal judge outside the Supreme Court ever used the personal invitation trick, and the Judicial Conference, made up of other judges, firmly shut it down. Regular judges would be loath to use that trick because a complaint about it would go into a proper process and would be investigated and measured against the law and the ethics code, and a conclusion would be reached, and that conclusion could be embarrassing. Only Supreme Court justices refuse to allow their conduct to be investigated or reviewed. My bill would fix that. Here's an example of the no investigations problem. The key fact to determine whether Justice Thomas was bound by law to recuse himself from the first January 6th committee case was what he knew about his wife's insurrection activities and when he knew it. On that fact, the lawfulness of his initial recusal decision turns. Yet Thomas has never been officially asked that question. It's a cover-up in plain view. The Supreme Court alone among federal courts is okay with that. My bill would fix that. Which brings us to Justice Thomas's recent non-disclosure of supposed personal hospitality from a right-wing billionaire and its problems. First problem, private jet travel is not in the personal hospitality exemption, which is limited to food, lodging, and entertainment. Exhibit 7. Some textualist, by the way. Second problem, Thomas said it was okay because he'd asked colleagues. But that Financial Disclosure Committee, it's there to ask about financial disclosure. Setting aside that its name should give a clue, Thomas knew the committee existed because concerns about his yacht and jet travel gifts from this billionaire were referred there in 2011, after some of these gifts were first revealed in this New York Times story, Exhibit 9. Third problem, there's no legal way not to disclose the property acquisition in Georgia. Fourth problem, some of this personal hospitality involved people dedicated to turning the court into a tool for right-wing billionaires, namely Leonard Leo. This guy doesn't have business before the court, his business is the court. This disclosure mess has again been referred to the Financial Disclosure Committee, which raises the question of the previous referral to that same committee of the same billionaire's gifts to Thomas of yacht and jet travel. The rules seem to require the committee to report its findings to the Judicial Conference. The records of the Judicial Conference are public, and the records of the Judicial Conference contain no mention of any such report. So what became of the 2011 referral? Did anyone intervene? Is the committee still considering the 2011 referral more than a decade later? There is much yet to learn, which is why last week I sent a letter to the courts asking for further answers. Exhibit 10. 3 things are needed to fix all this: better enforcement, better recusal rules, and better disclosures. My bill would do all 3. I thank Chairman Durbin for this joint hearing and look forward to getting to the bottom of this mess. Until there is an honest ethics process at the Supreme Court, these messes will continue. The court has conclusively proven that it cannot police itself. Nemo judex in sua causa. I ask unanimous consent that my exhibits be made part of the record.
Without objection. Senator Whitehouse.
Thank you, Chairman. Professor Frost, you distinguish between the adjudicative and the administrative function within the judicial branch. That has constitutional relevance to our ability to legislate?
Yes, I think that's a very important distinction.
Because we have no business interfering in the court's decision-making on matters before it, but as to the administration of justice, we do have the authority to pass laws, correct?
Yes, the Constitution intended Congress to play that role of judicial administration and not interfere.
In fact, Canon 4 of the Code of Conduct encourages judges to testify in legislative bodies regarding the administration of justice. And that would not be there if it were not appropriate for Congress to legislate regarding the administration of justice, would it?
Agreed.
Moreover, you mentioned the Ethics in Government Act, the Ethics Reform Act, and the recusal statute. Those are all laws passed by Congress?
Yes.
And they all apply to the court?
Yes.
Indeed, in some cases, using the word justices specifically, which is the term that applies to Supreme Court justices only, correct?
Yes.
And has the application of those statutes to the Supreme Court ever been challenged by the court itself in the years in which they've been in place, to your knowledge?
Not to my knowledge.
Judge Fogel, you were at the Judicial Conference for many years. You've had to have the role that the Judicial Conference was given by statute, by Congress, to administer these laws. In the context of administering these laws, particularly under the supervision of the Chief Justice, were you ever told that these laws were unconstitutional or that the Judicial Conference or the Financial Disclosure Committee should not enforce them?
No, Senator. The justices complied, as did all of the other federal justices, with the disclosure requirements, or at least they made an effort to.
And in fact, one of the rules, part of the law, is that if there is a financial disclosure violation, then the determination as to whether that violation was willful and is subject to civil penalties actually gets referred to the Attorney General for determination.
That's correct. What the committee does is it looks at the non-disclosure or the incomplete disclosure. It determines whether it's something that could be remedied. Usually the way the committee functions is remedial. They try to get the filer to comply with the disclosure requirements. But if there's a willful failure, then the committee has the authority to make that referral. And
it does so based on a determination that there's reasonable cause for someone to believe that this might have been a willful violation.
That's correct.
And then the willfulness determination gets made by the Attorney General.
That is correct, but I have to
say—
There are
civil fines that are potentially imposed if
Yes, sir.
Okay,
that's
go
correct.
ahead, finish what you want to say.
No, what I was going to say was that the committee tries very hard with the filer to make sure that every effort is made to get a proper filing. So,
in fact, it's okay for a judge, in fact, it's even encouraged for judges and justices to bring concerns about financial disclosure to the committee for a confidential opinion saying, here's what you got to do.
That's correct.
And Justice Thomas did not do that with respect to these filings.
I don't want to comment on Justice Thomas, but normally the committee is there to assist with questions like that.
So has the Judicial Conference, again under the supervision of the Chief Justice of the United States, ever suggested that it was unconstitutional for Congress to require that these forms be filled out, that if there are omissions in the forms that be referred to the Attorney General, and that a civil fine could be imposed on a justice for failure to file? Has that ever been raised in your conversations?
Not to my knowledge, sir. No.
Well, that's, I think, a little bit telling. I appreciate that. Mr. Payne, are you familiar with the concept of regulatory capture?
Yes.
Sometimes called agency capture.
Yes.
Fairly considerable literature about it in administrative law and economics.
Yes.
So I'll ask you a hypothetical. Let's just say hypothetically that there were an organized effort to capture, in the meaning of regulatory and agency capture, to capture the court in such a way that it was beholden to and ruled in favor of big special interests. That's the hypothetical. Here's the question. If that hypothetical were true, would any ethics concerns be raised by justices consorting with individuals or associating with groups involved in that capture scheme?
Yes, in that hypothetical, there could be potential conflicts of interest if someone was engaged in trying to influence the court and members of the court were engaging in activities with them.
Thank you. My time has expired.
Thanks, Senator Whitehouse. Senator.
The nutshell version of your testimony is that the wrong question was answered, i.e. willfulness rather than reasonable cause. It was answered in the wrong venue, to wit, a committee or subcommittee or perhaps individual determination instead of the judicial conference, as the statute suggests, with the result that the deliberations were, to use your words, opaque. They took place out of public view. Is that a fairly accurate summary?
Yes, with the caveat that it appears to me, having revisited this and having more information in some respects than I had in 2012, it appears to me that no decisions and possibly no action was taken in 2011. And that's another concerning matter.
The one place where there is an opportunity for public awareness of what is happening in this process is at the judicial conference, correct?
Well, that's not completely correct either, because I have scoured the Guide to Judicial Policy, which is not a public document, and the judiciary's description of the judicial conference and its committees. There is nothing in there that says that a judge or justice can't talk about what transpired. However,
I'm asking a bit of a different.
Well, I know, but however, I expect that some of you at least have attended those meetings. The public is not allowed to observe, to see the proceedings. They're allowed to see this hearing. They can judge my credibility, and if they're interested, my motives. But that kind of transparency doesn't exist in the judicial conference. And there are certainly things that should properly be discussed confidentially and maintained as confidential, particularly before decisions are made, the essence of the deliberative process privilege, pre-decisional, but striking the right balance between transparency and accountability is, I think, for the judicial conference, like every branch of government, important.
The one thing that is made public is the report of each judicial conference after the meeting, correct?
A report of the proceedings.
Yes.
Which is a summary.
And the report of the proceedings would tend to include reports to the conference from its committees. So the one way that any of this would become public is only if the determination that was made here was actually referred by the Financial Disclosure Committee to the Judicial Conference, and then that would be reported in the summary of the Judicial Conference's activity, correct?
Yes.
And that did not happen in this case.
The reports of the Judicial Conference, the reports of the Financial Disclosure Committee were under Judicial Conference policy required to include everything that the committee had discussed and decided since the last conference meeting, even if no recommendation for conference action was being made. The 4 reports starting in March 2011 of the Financial Disclosure Committee to the conference it contained no reference, no hint that any letters had been sent or any issues have been raised.
So the only disclosure that the Judicial Conference provides any record of in these matters is the April 30 letters from the Judicial Conference that summarily say nothing has been presented to support a determination that Justice Thomas's failure to report the source of his spouse's income was willful, or that Justice Thomas willfully or improperly failed to disclose information concerning travel reimbursements. That is it that has been public, correct?
As far as I know, yes.
As far as I know, too. I think as the convention is to go to the leading Republican, that, Senator Lee, is you right now, and then Chairman Durbin. Good fortune when I come to deliver remarks on the Senate floor and get to follow Senator Sullivan's Alaskan of the Week speeches. And his discussion of his constituent, Alberta, reminds me of a very, very dear person in my life, Florence Cairns Murray, born just a little bit ahead of Alberta, 1916, but like Alberta, served in the U.S. military. She was a WAC, Women's Army Corps, lieutenant colonel, and then broke essentially every glass ceiling you could break in Rhode Island politics and in the Rhode Island judiciary, becoming a very respected and renowned Rhode Island Supreme Court justice. So I will take the liberty of joining my colleague, Senator Sullivan, and wishing his constituent a happy birthday, but I also wanted to share the memory of a very dear Rhode Islander who I think would have gotten along very well. I'd like to be a witness, a fly on the wall at the conversation between Florence and Alberta.
Alaska.
To my friend and colleague from Rhode Island, I will gladly pass along your birthday greetings to Alberta. Thank you very much.
Mr. President.
Senator from Rhode Island.
Mr. President, I rise this evening, now for the 22nd time, to keep unmasking the far-right scheme to capture and control our Supreme Court. This scheme is funded by creepy right-wing billionaires who stay out of the limelight and let others, namely Leonard Leo and his crew, operate their scheme. And how are they benefiting from the scheme? It's hard to track which right-wing billionaires are involved, and that is by design. But thanks to intrepid reporting from ProPublica and others, we're learning more all the time. And every day it becomes harder for the billionaire-friendly justices and their political allies to pretend with a straight face that all is kosher at the court. I have previously described the noxious cocktail of this court capture scheme: creepy right-wing billionaires, phony front groups, amenable justices, large sums of money, and secrecy. I don't know whether they take that shaken or stirred, but those seem to be the common ingredients. To chill that court capture cocktail, we can add one more ingredient: Alaskan glacier ice. But I'll get back to that later. First, let's review the origin story of Justice Samuel Alito. It begins with the bipartisan Senate rejection of Judge Robert Bork, which infuriated Bork's far-right backers. On the court were Justices Souter and Stevens, both Republican appointees, but they wouldn't help the billionaires. So the angry chant went out from the far right: no more Souters, no more Stevenses. Then President George W. Bush got an appointment and nominated his friend and trusted White House counsel, Harriet Miers. A Republican president nominates a personal friend and rock-ribbed conservative Republican, a woman, to replace Sandra Day O'Connor, and the attack on her comes from the right. The far-right billionaires wouldn't have it, and their operative, the aforementioned Leonard Leo, oversaw the project of taking her down. And in her place came the ever so reliably billionaire-friendly Sam Alito. This switch, Myers for Alito, gave Leo immense cred with the billionaires who have since made him a very rich man and helped him launch his armada of front groups, of which this array is just a selection. These three groups are the groups from which he takes revenue for himself and through which he manages these two groups, a coordinated 501c3 and 501c4. That's sort of the latest and greatest technique in dark money political manipulation, a conjoined 501c3 and 501c4, usually common offices, common staff, common funders, common mail drop, all of that. And around this common core are what are called fictitious names. That's the name for it under Virginia law. So 85 Fund is also the Judicial Education Project under a fictitious name. It is also the Honest Elections Project under a fictitious name. It is also the Free to Learn under a fictitious name. Concord Fund is also Judicial Crisis Network under a fictitious name. Honest Elections Project Action under a fictitious name, and Free to Learn Action under a fictitious name. That's quite a lot of confusion, and it's designed to be confusing. Scroll on to 2021. By that time, I've been calling out obvious issues at the Supreme Court, published articles, delivered speeches, wrote law reviews, even wrote a book. Alito, speaking at the University of Notre Dame, bemoaned what he said were, and I quote, unprecedented efforts to intimidate the court. He went on to say that the media was suggesting that, I quote again, a dangerous cabal is deciding important issues in a novel, secretive, improper way in the middle of the night, hidden from public view. That, of course, referred to the sudden surge under Trump in the court's use of its shadow docket to quickly change the law without hearing full public arguments. Alito's speech then was considered pretty extraordinary, airing of grievance by a Supreme Court justice. In response, I wrote an op-ed explaining that Justice Alito had participated in a pattern of decisions, among them the shadow docket ruling leaving in place, pre-Dobbs, Texas's bounty hunter anti-abortion law. A pattern of big wins for big right-wing donors with little regard for fact or precedent. I argued that Americans' perception that the court lacks independence and the resulting drop in approval isn't some left-wing figment. The evidence showed a clear pattern. When big right-wing donor interests came before the court, the Federalist Society justices on the court would regularly trample precedent and contort the facts in the law to deliver the donors political victories. Not a figment, a pattern. Then, of course, came the Dobbs case, which actually took away a constitutional right from women. For 5 decades, women had the right to choose when to have children. That constitutional right appeared safely protected in Supreme Court precedent. Then, from a list mysteriously prepared by Leonard Leo and the Federalist Society, President Trump appointed 3 justices to the court. Now, I say mysteriously because the Federalist Society evidently never had any formal proceedings to develop any list. But it offered no correction when Trump kept calling it his Federalist Society list. Well, the next thing you know, that constitutional right was taken away by justices who, in their confirmation hearings, had told the American public and the Senate Judiciary Committee that Roe was settled law. Settled, that is, until they had the votes to unsettle it and make up their own. As Justice Elena Kagan observed, If there's a new member of a court and all of a sudden everything is up for grabs, all of a sudden very fundamental principles of law are being overthrown or being replaced, then people have a right to say, what's going on there? That doesn't seem very law-like. And she was right. Years after he had assured us Roe was settled law, it was Justice Alito who wrote the decision in Dobbs. Alito's draft opinion infamously leaked well ahead of the decision, causing rampant speculation about who leaked the opinion and why. Chief Justice Roberts directed the marshal to investigate, interviewing clerks and support staff and even searching employees' personal phone records. But with the justices, the marshal undertook some other, also mysterious, iterative process, and the investigation proved inconclusive. Curiously, days before the opinion leaked, the Wall Street Journal editorial page had predicted the Dobbs decision, raising the suggestion that someone had a source in the court. The editorial correctly predicted what Alito knew, that Alito would write the decision for the majority so long as Chief Justice Roberts couldn't pull another justice to join a more moderate middle ground decision. Then, this past April, Justice Alito was featured in a highly sympathetic interview on the Wall Street Journal editorial page. Alito spoke about his opinion's leak and said, "I personally have a pretty good idea who is responsible, but that's different from the level of proof that is needed to name somebody." Any major newspaper would have put an exclusive interview with a Supreme Court justice on the front page, but it would then have been subject to fact-checking. This opinion piece looked like an article, but it appeared in the Journal's notoriously fast and loose with the facts opinion section under a double byline. One was a Wall Street Journal editorial staffer, and the other was David Rivkin, a right-wing lawyer who represented the states challenging the EPA's Clean Power Plan before the Supreme Court. A quick detour about the Wall Street Journal editorial page's ties to the right-wing ecosystem. Right-wing bizarro land likes to ape the legitimate world. In the legitimate world, there's a Pulitzer Prize. So right-wing bizarro land has its own Bradley Prize, which, guess what, has provided hefty prize money to several Wall Street Journal editorial page writers, $1 million cash in all. This editorial piece quotes Alito saying, "We are being hammered daily and I think quite unfairly in a lot of instances, and practically nobody is defending us." In the piece, Justice Alito declined to talk about the Clarence Thomas ethics problems reported by ProPublica. Extravagant vacations worth as much as $500,000 paid for by right-wing billionaire mega donor Harlan Crow and not disclosed. That report was later followed by an additional ProPublica story detailing the billionaire's purchase of properties from Justice Thomas and his family members, also not properly disclosed, and payments for years of tuition for the justice's grandnephew who the Thomases were raising, also not disclosed. Justice Alito's silence on the Thomas bombshell became all the more notable when 2 months later, ProPublica published another bombshell, this one about Justice Alito. Same cocktail ingredients. In this case, a right-wing billionaire, an amenable justice, undisclosed private jet travel, an exotic vacation, all very expensive, all secret. Justice Alito's private jet travel to this all-expenses-paid Alaskan fishing vacation was paid for by a hedge fund billionaire, Paul Singer, who contributed over $80 million to Republican political organizations, and whose Elliott Management Group is one of the largest donors to the National Republican Senatorial Committee. This is a politically involved right-wing billionaire. Later, the billionaire's firm had business before the court, and in that case won billions of dollars. No disclosure by Alito, no recusal. Charles Gay, an Indiana University law professor and leading expert on recusals, had this to say: if you were good friends, what were you doing ruling on his case? And if you weren't good friends, what were you doing accepting this? But wait, there's more. The tab for Alito's stay at the Salmon Lodge in Alaska was covered by a different billionaire. If you're keeping score, we're now up to 3 billionaires. This one is named Robin Arkley, and he funded the launch of Leonard Leo's advocacy group, the Judicial Crisis Network, also heavily engaged in right-wing political influence focused on the court. Leo, the operative behind the current right-wing Supreme Court supermajority, not only organized Alito's trip, he gallivanted off to Alaska with the justice and the billionaires. By my count, after yet another story about Justice Thomas, we are now up to 6 right-wing billionaires attending to the care and feeding of 2 justices, Thomas and Alito. And there are all sorts of links among them and with the ubiquitous Leonard Leo. So many justices, so many billionaires, so many gifts. But there's even more. Alito was not the first justice to stay at this particular lodge. Justice Scalia also took a private jet to the lodge, courtesy of billionaire Arkley, and also did not disclose the gift. In one memorable bit of color from that ProPublica story, Scalia was described as mixing martinis made with ice chipped off of a glacier. There, you thought I'd forgot that, but I didn't. The evening before the Alito billionaire travel story ran, the Wall Street Journal comes back into the picture again. Alito tried to preempt ProPublica's reporting by taking to the Wall Street Journal editorial page. In the op-ed, Alito argued that he didn't need to disclose the private jet travel under federal law because the private jet should be considered a facility, and that his seat on the private jet would have otherwise been empty, so it was free and there was no gift. I won't go into how laughable these arguments are. That is a separate case. What's important is that these arguments were printed on the Wall Street Journal editorial page without investigation or comment by the page, taken at face value. Oh, and by the way, the cost of that charter, the private jet travel would have cost over $100,000 each way. In that Wall Street Journal editorial page piece from the spring, Alito had said about the court's collapsing approval, well, yeah, what do you expect when you're day in and day out? They're illegitimate. They're engaging in all sorts of unethical conduct. They're doing this. They're doing that. Justice Alito's complaining has it completely backwards. The problem is not that Americans are pointing out the ethical lapses at the Supreme Court. The problem is the ethical lapses at the Supreme Court. The Roberts Court justices' behavior is crashing public trust in the institution, and justifiably. First, with preposterous judicial behavior that no other judge would indulge. Second, with outrageous violations of quite clear rules and procedures judges are supposed to follow about reporting those gifts. Third, with preposterous excuses for the bad behavior and the reporting violations. And fourth, with no process to ever even try to get to the truth, to establish the facts. It is a mess. Ideally, the justices would start fixing that mess on their own. The court and the Judicial Conference, which Roberts chairs, have the ability to fix this. But so far, they won't. I suspect there is a lot more to be found out about this mess, and they don't want those further disclosures, so they would just as soon pull a rug over the whole thing, but that won't work. Congress also has the ability to write ethics rules for the justices. Remember, Congress created the judges' financial disclosure requirements in the Ethics in Government Act. And Congress created the judicial recusal law, which the justices are also required to follow. And Congress created the Judicial Conference, which administers financial disclosure and code of conduct matters. Clearly, the Article I legislative branch can legislate in this area. Clearly, we can oversee agencies that we have created and laws that we have passed, and indeed we have for decades. In the coming days, the Senate Judiciary Committee will mark up my Supreme Court Ethics Recusal and Transparency Act. This is a very important step forward in this process, and I thank Chairman Durbin for his leadership. This bill would put basic ethics guardrails and transparency measures in place to help ensure the American people that they can get a fair shot at the Supreme Court, even if they don't have a private jet. Today, in the court that dark money built, the honors system has flagrantly failed. We need to legislate, we need to investigate, and we need to fix this mess for the American people. To be continued, Mr. President. I yield the floor. Thank you. Let me start by thanking Chairman Durbin for this markup of our Supreme Court Ethics Recusal and Transparency Act and the rest of my Democratic colleagues for co-sponsoring it. This bill would directly address some of the already disclosed misconduct we've seen at the Supreme Court recently. Comprehensive judicial ethics legislation is overdue, but it's worth remembering how we got to today's markup. Let me first be candid about my belief that the Supreme Court has been captured by special interests, much like a railroad commission in the 1890s might have been captured by railroad barons to decide things their way. I knew ethics were haywire at the Supreme Court when I determined that Justice Scalia had taken many dozens of unreported freebie vacations, often with political companions. His theory, evidently, was that a personal invitation from a resort owner he'd never met made the free vacation the sort of personal hospitality that did not need to be reported under federal law. That is, of course, ridiculous. And when I got this notion before the Judicial Conference, they shot it down in flames, the verdict of their fellow judges. Other justices had witnessed this behavior over decades, but did nothing about it, other than in some cases to copy it. Then came the flotillas of coordinated front group amici who showed up at the court. Some amici have been paid by parties. Others have masked special interests out to influence the law. There is a disclosure rule for all of this, but its enforcement is a failure. Here's an appendix I filed showing who is behind one case's flotilla of front groups. The biggest flotilla, no surprise, appeared in the Bonta dark money case, supporting a corporate appendage of the Koch brothers' main political dark money battleship, Americans for Prosperity. I counted 55. 55. And these right-wing front groups have a statistically staggering record of certain justices ruling their way. Then came Justice Thomas in the January 6 cases. The lawfulness or unlawfulness of his failure to recuse depends on simple facts: what he knew about his wife's insurrection activities and when he knew it. To this day, the court has engaged in zero effort to make that factual determination. Worse, it has no means to. It is the only court in the country, and perhaps the only court in the world, with no ethics process at all. Then came the news that six politically active right-wing billionaires have been paying household expenses, engaging in financial transactions, and providing massive secret gifts of travel and hospitality for at least 2 justices. Not one person on this committee could or would accept such a bonanza, let alone keep it secret. Nor would executive branch officials, nor would any other federal judge. And that's before you throw in the repeated companionship of the justices on these travels with the operative at the heart of the court capture scheme. Yet the Supreme Court remains supremely idle. Last 2 points. 1, the judiciary has a process for resolving ethics questions and giving ethics advice. The justices seem uniquely to refuse to follow it. For instance, asking random colleagues and friends about financial disclosure obligations instead of asking the actual financial disclosure committee of the judicial conference that is there for that purpose. And the excuses when they're caught have been laughable. For instance, that they don't need to disclose these junkets because a private jet airplane is a facility. And the traveling on that private jet airplane is not travel, but is food, lodging, or entertainment. Remember, as we debate this, the court's financial disclosure requirements are a law passed by Congress. Its recusal requirements are a law passed by Congress. And the body that implements financial disclosure and code of conduct issues is the Judicial Conference, a body created by Congress. Please, let's not pretend that Congress can't make amendments to laws Congress has passed or oversee agencies Congress has created. For decades, the justices themselves have never objected to and have actually repeatedly and without complaint complied with this structure. So even the court has demonstrated it does not believe that canard. We are here because the highest court in the land has the lowest standard of ethics anywhere in the federal government. And justices have exhibited much improper behavior, not least in hapless efforts to excuse the misdeeds. This cannot go on. Defending this behavior defends the indefensible. Thank you, Chairman. I would like to make a few points as we wrap this up. The first is I would react to the comments of some of my colleagues that Democrats want to pack the court. My sense is the court has already been packed. It has been packed as the result of a very long and expensive effort run by a handful of secretive right-wing billionaires through a bunch of front groups. The tally of the cost of the operation has risen from the original $250 million estimate of the Washington Post to now $580 million spent on trying to make sure that those billionaires succeeded in what has been characterized in this room as the long effort to make this a conservative court. The question of whether or not it is appropriate for lower court judges to stand in some degree of judgment over the administrative question of whether or not there's compliance with rules is actually the current state of the judiciary. That is the way it works right now. So objecting to that is objecting to present reality. Let me start by pointing out that there are two sides to a judge's job. One is the judicial side, adjudicating matters, and the other is administrative side, which includes the ethics part of a judge's job. You have a clue which role the judge is playing if they're wearing a robe. If they're not, it's very likely the administrative side of their work. In the administrative side of their work, where the ethics questions are handled, those determinations go to the judicial conference. That's the same body I mentioned earlier that was established by Congress and that implements the financial disclosure laws passed by Congress and the recusal laws passed by Congress. It is made up essentially entirely of lower court judges. One justice sits on it as chair, the Chief Justice. And questions about financial disclosure of the justices are sent there now. We know that because we've seen it happen. In the first round of Harlan Crow to Clarence Thomas yacht and jet free travel disclosures back in 2011, that was sent to the Judicial Conference and to its Financial Disclosure Committee. Its Financial Disclosure Committee is composed entirely of lower court judges, circuit chief judges and district chief judges. That is who resolved the matter of that first round of gifts from Harlan Crow to Clarence Thomas. And the second round, right now, that the Judicial Conference is reviewing, was again sent to the Financial Disclosure Committee, again made up entirely of lower court judges. So the objection that lower court judges would make a determination about whether justices have complied, for instance, with financial disclosure rules, that's the present state. That's the present state. And the other question that went before them recently was this question of Justice Scalia's maneuver, you want to call it that, of reading a personal invitation from a resort owner with whom he had no personal relationship as a matter of personal hospitality. When that question went back for determination, it went back to the Judicial Conference. And it was the Judicial Conference made up of lower court judges that said, no, that doesn't fly, that is not legal, that is not what the personal hospitality disclosure rule permits. So thank you for letting me have a chance to make that record. I don't know if we have the... I don't know if I'm holding up a vote at this point. Nope, not yet. Okay, we're still waiting for people to come back from the voting. So, you know, there are a lot of canards that are flying around in all of this. The canard that lower court judges can't make decisions about the administrative side, the ethics piece of Supreme Court justices' behavior is just simply belied by the fact that it has happened exactly that way over and over and over again, and without objection. Without objection. When Justice Thomas's first round of secret yacht and jet gifts from Harlan Crow was referred to the Financial Disclosure Committee, he did not say, wait a minute, you can't send that to that body. They're all lower court judges. He went along with it. And no Supreme Court justice has ever complained about lower court judges through the Judicial Conference exercising their judgment about administrative, financial, and ethics matters. So that just ain't so. And the argument that we are up against an attack on the independent judiciary and that this violates separation of powers, again, is belied by the acts of the justices themselves. The Judicial Conference has existed for decades. The court knows it exists because the Supreme Court Chief Justice chairs it. They have never objected to that being an intrusion into separation of powers because it was established by Congress. And the financial disclosure rules that Congress established. Again, when the matter about the first round of Harlan Crow to Justice Thomas secret yacht and jet travel gifts was sent to the Judicial Conference, nobody said, you can't send it there because it violates separation of powers. They didn't say you can't do it because it's lower court judges, and they didn't say you can't do it because it's separation of powers. And that's because both of those arguments are completely false. There are ways to solve this problem that work squarely within the constitutional principle of separation of powers, a principle that I revere. As one of my Republican colleagues said today, there's also the question of checks and balances, and that we have to allow power to check power. Allowing Congress the power to check abuses in the judicial branch is a long established and proven fact that the Supreme Court has for decades gone along with without complaint, even when, and perhaps particularly when, it involved justices themselves. And indeed, after the Judicial Conference said, nope, you cannot fake personal hospitality if it's a corporate venue. You cannot fake personal hospitality just because it's a personal invitation. You cannot fake personal hospitality if there's not a real and long-standing personal relationship. When they said that, they were exercising powers given to them by Congress. And there was no objection to that from the Supreme Court. Indeed, Thomas put out a rare statement saying he would abide by that. He did not say that's unconstitutional. He did not say lower judges shouldn't do that. He did not say there's a separation of powers problem here. He said, yep, I will follow that new rule.
Without objection, the senator from Rhode Island is recognized.
I also have 4 requests for committees to meet during today's session of the Senate with the approval of the majority and minority leaders.
Without objection, so ordered.
Thank you. All right. To business. I'll call this my let's say speech. Lawyers know what a hypothetical is. We'll talk about some hypotheticals related to the scheme to capture the court. Let's say, Mr. President, that you're a creepy billionaire, and it is your plan to capture and control the Supreme Court, to take it over, just like 19th century robber barons would have taken over and captured the railroad commission that set the rates for their own railroad. Let's say you sent millions of dollars, secret dollars, to the Federalist Society for it to funnel money to its employee and your operative, Leonard Leo. Let's say that Leonard Leo got his cred with you and your right-wing billionaire pals when he helped you kill the nomination to the Supreme Court of President George W. Bush's friend and White House counsel, Harriet Miers. a political hit job from the far right against a Republican president's nominee, which produced none other than Sam Alito. Let's say you also sent millions of dollars to Leonard Leo's Judicial Crisis Network, a fictitious name front group for another front group operating out of the same hallway, on the same floor, in the same building as the Federalist Society. Let's say you sent Judicial Crisis Network secret millions of dollars, checks as big as $15 million, checks as big as $17 million to run ads against Merrick Garland, to help Mitch McConnell block his confirmation by the Senate. Let's say you also send millions of dollars, secret dollars, identity laundered through front groups like 501c4s and Donors Trust, which exist for the purpose of scrubbing off your identity from your money. And through the 501c4s and through Donors Trust to Republican political groups like super PACs controlled by Mitch McConnell. And let's say with those secret millions funneled into those super PACs, you acquired loyalty and obedience from Republican political figures. Let's say that that worked. Let's say that for your millions of dollars to the Federalist Society, the Federalist Society allowed you to use its name on a list of Supreme Court nominees that you and your right-wing billionaire pals and Leonard Leo cooked up. A list that the Federalist Society never considered or approved, never an agenda item, never a vote, but a list from some back room of the Federalist Society, pulled together by Leo and the billionaires, that candidate Trump promised to follow. And let's say that for that Trump promise to let you pick Supreme Court justices, you agreed to hold your nose and not object to Trump's candidacy. Let's say that Trump kept that promise and nominated your chosen ones to the Supreme Court. And let's say that when Trump kept that promise and nominated your chosen ones, you sent millions more to the Judicial Crisis Network and to Mitch McConnell's political operation, not just to stop Merrick Garland, but to push the confirmation of your chosen ones, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett. Let's say that you funded dozens of front groups to bring cases and to file briefs at the Supreme Court at your orchestrated direction. 10, 11, 12, in one cases, 50 at a time, like piano keys on the piano. And you sent that message through those front groups in those briefs to remind your chosen ones what it is exactly that you wanted them to do in those cases. And let's say that the chosen ones produced an amazing statistically stunning record of doing in the opinions they produced just what your front groups asked. Let's say you and your fellow billionaires played your front groups like piano keys, and your chosen justices harmonized perfectly with their direction. And let's say that to keep your chosen ones loyal and happy and entertained, you secretly paid for their personal lives. You paid for family tuitions. You bought family houses and let family members live rent-free. You paid for lifestyles of the rich and famous level vacations, including free travel to resorts, on private jets, travel on private yachts, and you gave them expensive gifts, and you directed money to their spouses, and of course you hung out with them. And let's say that that last part, keeping them loyal and happy and entertained with all those gifts, was illegal. Illegal. Let's say that your loyalty gifts program required the chosen ones to file false federal disclosure forms and perhaps even false tax returns. Let's say that your loyalty gifts program might put you in trouble with the tax man for claiming false business expenses. How could that be? Let's say that the chosen ones were calling this bonanza of freebies personal hospitality. Personal hospitality, a term of art allowing non-disclosure under the disclosure laws. Let's say that they were all calling it personal hospitality, but you were calling the bonanza deductible business expenses of corporate yachts and jets. Then it wouldn't all add up. That's a lot of let's say, I know, but that's about what we're looking at with the Supreme Court right now. We know it's not one right-wing billionaire, but a little bunch of them. We don't know all the freebies yet. Maybe we only know 10% of the freebies. We know that there has been no meaningful investigation of this. So there's lots left to learn. And that's our job in Congress, to investigate malfeasance in government and expose abuse so the citizens can see what's been going on and laws can be changed to better protect against that kind of abuse. So, let's say Congress starts doing its job and starts asking nosy questions. What's a creepy billionaire to do? That's easy. You lawyer up. You refuse to cooperate. You're a billionaire, remember? So you can pay lawyers $1,000 an hour until the cows come home and not even notice it. 1,000 hours of $1,000 lawyering wouldn't cost you 1,000th of your wealth. You live above the law, sheltered by your billions. You actually direct the law through your chosen ones on the Supreme Court. The impertinence of being investigated is insufferable. So this is what you send. Here are two actual lawyer letters. One was sent by the lawyer for the billionaire Harlan Crow. The other was sent by the lawyer for the billionaire's operative and his painting mate, Leonard Leo. When I say painting mate, I mean this painting that Harlan Crow, the billionaire, has of his time with Clarence Thomas, one of the chosen ones, and Leonard Leo, the operative. Couldn't be more cozy. So, you send these letters. Leo, by the way, has himself joined your Billionaire Boys Club. He did so when one of your billionaires, Barry Seid, set him up with his own $1.6 billion slush fund held through a Utah 501c4 front group confected for that transaction. Let's walk through what these letters say, because the arguments are so preposterous, it's hard to imagine they could be made in good faith. As you can imagine, when letters come from lawyers from billionaires in the Billionaire Court-Packing Boys Club, the letters are pretty alike. The first one, for Crow, says, Congress does not have the constitutional power to impose ethics rules and standards on the Supreme Court. The second one, for Mr. Leo, says, your inquiry exceeds the limits placed by the Constitution on the committee's investigative authority. Then there's a third one for another billionaire where they just did one paragraph. Basically, it just says, yeah, what Leonard Leo's lawyer said. This inquiry exceeds the limits placed on the legislature by the Constitution. We refer you to the relevant portions of the letter directed to you on behalf of Mr. Leo. I feel kind of bad for these lawyers because I don't think you can bill very much for one paragraph, whereas these guys could bill quite a lot. Anyway, poor fellas. So let's look at these other letters. And I ask unanimous consent to append the letter of lawyer Bop for billionaire Crow and the letter of lawyer Rivkin for billionaire operative Leo as exhibits at the end of my remark, with the short one-paragraph letter, the tag-along letter from Attorney Clark.
Without objection.
Lawyers Bop and Rivkin both tell me that investigating their clients' activities is unconstitutional under the separation of powers. We can't legislate about Supreme Court ethics, so we can't investigate Supreme Court ethics. First, remember that alongside separation of powers is its twin, checks and balances, which requires branches, like the legislative branch, to check and balance the behavior of other branches, like in this case, the judicial branch. That's what we're doing here, checks and balances. Let's dive down into the specifics a little bit more. There are primarily three topics. One, did the billionaire or the operative take improper advantage of the tax code in their dealings with the justices? That's what we're looking into. The Finance Committee has its own investigation along with the Judiciary Committee to focus on the tax side of this. Well, I got to say, it's hard to see how abuse of the tax code by a private citizen in his tax filings could raise any separation of powers concern. That's between the tax filer, the government, and the law. The justices are simply not a party to that. Even were we looking at the justices' own tax filings, were it to come to that, they'd be investigated in their role not as justices, but as taxpayers. Being a justice doesn't allow you to violate the tax laws or immunize you from tax investigation or permit you to make actionable false statements in your tax returns, any more than being justice would allow you to commit any other offense. So there's tax abuse. Issue one, no visible separation of powers angle to it. Issue two, did the justices receiving gifts and emoluments from the billionaire or the operative properly report them? Or did the judicial gifts reporting system fail here? The billionaire's lawyers say, that's not our business. Well, that is Congress's business for two pretty obvious reasons. First, the reporting requirements are a law passed by Congress whose implementation we can absolutely oversee like any other law passed by Congress. And this law includes justices. Second, the implementing body of that law is the Judicial Conference, a body created by Congress, whose activities we can absolutely oversee. We created it. The notion that Congress cannot investigate to see if an agency it created is properly implementing laws Congress passed is ludicrous on its face. Peripherally, it's worth noting that the Supreme Court has never objected on constitutional grounds to that body or to those laws. The Chief Justice actually chairs the Judicial Conference without objection to its congressional nature. When questions about Justice Thomas's first round of free yacht and jet travel from Harlan Crow were raised a decade ago, those concerns went, under the law, to the Financial Disclosure Committee of the Judicial Conference for review, without objection to the power of review by Justice Thomas. And when Thomas's recent round of billionaire-funded free yacht and jet travel, Crow-Thomas 2.0, you might call it, raised questions anew, again, those questions went to the Financial Disclosure Committee of the Judicial Conference for review, where those questions penned now, again, without objection. Nobody said the Judicial Conference is unconstitutional, the reporting laws are unconstitutional, you can't look at this. Congress could never pass those laws. Congress could not create the Judicial Conference. Nobody said that. Additionally, when Justice Scalia's trick came to light of obtaining dozens of free hunting vacations and not disclosing them because it was supposedly a personal invitation, which supposedly made it personal hospitality that didn't have to be disclosed, the question of that trick's propriety went to the Financial Disclosure Committee of the Judicial Conference for review. The conference shut that trick down firmly. And Justice Thomas conceded he would abide by the Judicial Conference's determination, again, with no assertion that there was anything unconstitutional about it. So the separation of powers argument, in addition to making no sense, founders on the decades-long acceptance in real life by Supreme Court justices of our congressional role through these laws and through the Judicial Conference. Here's another argument they make. This is an interesting one. We've been too mean. We've been too mean looking into these facts. They that argument up in constitutional terminology, but that's it in a nutshell. I have used the analogy describing Leonard Leo's role in the billionaire's court capture scheme of a spider in a web. They think that's too mean. The problem with that too mean argument is that it assumes the result. If, in fact, there is a secret operation to capture and control the Supreme Court for the benefit of special interests, and if, in fact, Leo is its key operative, it's not actually all that mean to make an analogy to a spider and a web. It's actually pretty mild and quite descriptive. The accusation that we are doing this just to be mean and that it's unfair to ask questions presumes that there is nothing secret and sordid and wrong that would be revealed by our investigation. It's a little like saying the police can't investigate me because it would be unconstitutionally unfair because I'm so innocent. Well, that's what the police investigation would reveal. Just as this congressional investigation, unless successfully obstructed by the billionaires, might very well reveal a dark episode of secret corruption of our highest court, perhaps even the most covert, most persistent effort at judicial corruption in our country's history. To be continued, Mr. President. I'll be back with more of this story. And with that, Mr. President, last week I spoke about the scheme of corruption by right-wing billionaires out to capture the Supreme Court. I mentioned their lawyers' blockade of our investigation into this corruption and described then how little sense their lawyers' arguments made. That brings us to this speech today. The connection is that those, in my view, nonsense lawyers' arguments badly needed propping up. And who should come to the rescue but United States Supreme Court Justice Sam Alito. Alito's actions propping up that argument caused me to write this ethics complaint against him. I ask unanimous consent that it be appended as an exhibit at the end of my remarks.
Without objection.
Thank you, Mr. President. This complaint highlights some of the Supreme Court's current legitimacy problems, which are legion. One is that the court has no procedure for an ethics complaint. I had to write to Chief Justice Roberts, both in his capacity as Chief Justice and in his capacity as chair of the Judicial Conference, because unlike in every other federal court, there is no clarity about process. The Supreme Court has no formal process for receiving or investigating such complaints, so they go there to die. Complaints about Supreme Court justices have sometimes been referred to the Judicial Conference, and there they have mostly disappeared. So it's a mess. The Supreme Court, the body with the highest responsibility to police proper procedure and fair fact-finding throughout the rest of government, has no clear and proper procedure for itself. That's weird, and that's wrong. Nothing prohibits the court or the Judicial Conference from adopting procedures to address complaints of misconduct by the justices. They just haven't bothered to. The most basic modicum of any due process is fair fact-finding, but they have no process at all to find out even what the facts are. That is simply not defensible. That has to change, and my complaint presents the court and the conference that opportunity. Now, let's move from procedure to the substance of my complaint about Justice Alito. At one level, it is an obvious slam-dunk ethics violation. At another, it will take a lot more digging. Let me explain. My complaint relates to a so-called interview published on the Wall Street Journal's editorial page July 28 of this year. How it's both an interview and on the Wall Street Journal editorial page, I'm not going to explore. Justice Alito was the person interviewed. His interviewers were David Rivkin and James Taranto. And in this interview, Justice Alito offered his legal opinion that, and I'm quoting him here, no provision in the Constitution gives Congress the authority to regulate the Supreme Court, period. That's the end of his quote. Now, that comment wasn't just floating in the ether, it was related to my Supreme Court ethics bill, the Supreme Court Ethics, Recusal, and Transparency Act, which the Senate Judiciary Committee had advanced just 1 week before. And it also related to an array of congressional oversight information requests from the Senate Judiciary Committee and from the Senate Finance Committee. More on that later. Back to the slam dunk part. I sit on the Senate Judiciary Committee, where we hear in every Supreme Court confirmation hearing that it would be improper, that it would be wrong, even in a confirmation hearing, to express opinions on matters that might come before the court. Well, obviously, Alito's interview comments, his Wall Street Journal editorial page opining, touched on a matter that might come before the court. That's the slam dunk. Look at what other justices have testified about this opining problem. But let's start with Alito himself, who testified in his confirmation hearing that it would be, and I quote him here, improper, and I quote him again here, a disservice to the judicial process for a Supreme Court nominee to comment on issues that might come before the court. His words. Consider also Justice Thomas, who testified that such opining would, and I quote here, leave the impression that I prejudged this issue, which would be, he said, inappropriate for any judge who is worth his or her salt, end quote. Justice Kagan told the committee it would be, and I quote her, inappropriate for her to, and I quote, give any indication of how she would rule in a case, even in a somewhat veiled manner. Justice Kavanaugh testified that nominees, quoting again here, cannot discuss cases or issues that might come before them. He went on that prejudging an issue in this manner is, and I quote, inconsistent with judicial independence, rooted in Article 3. And he continued that litigants who come before the court have to know we have an open mind, that we do not have a closed mind. He quoted Justice Ginsburg, no hints, no forecasts, no previews. Justice Gorsuch went one better in his confirmation hearing. He actually testified that this no opining rule applies to discussions about Supreme Court ethics, the exact topic of Justice Alito's Wall Street Journal opining. Senator Blumenthal on the committee had asked Judge Gorsuch about proposed ethics rules for the Supreme Court, and whether they would violate separation of powers. Gorsuch answered, as I say right here, as I quote, "Senator, I'm afraid I just have to respectfully decline to comment on that, because I'm afraid that would be a case or controversy, and you can see how it might be. I can understand Congress's concern and interest in this area. I understand that. But I think the proper way to test that question is the prescribed process of legislation and litigation." End quote. In sum, the court itself is plainly on record that this sort of opining is wrong. So that is broken rule 1, just offering the opinion. But it gets worse. This was not just general opining out into the general ether. Alito's comments referred to a specific ongoing legal dispute. Let me explain. There are ongoing Senate investigations into the scandal of secret billionaire gifts to certain justices. The Senate Judiciary Committee is investigating reports that Supreme Court justices accepted and improperly failed to disclose, in violation of Congress's disclosure laws, lavish gifts from billionaire benefactors seeking to influence the court. And the Senate Finance Committee is investigating federal tax compliance regarding those undisclosed gifts. Were tax laws broken? Were proper declarations made? In those congressional investigations, requests for information have been sent out. In response to those requests, objections have been raised. And here's where Alito comes in. The objections by the billionaire's lawyers assert that Congress has no constitutional authority to legislate in this area, hence no authority to investigate. They assert, in my view, plainly wrongly, that our constitutional separation of powers blocks any congressional action in this area, which in turn, they assert, also plainly wrongly, in my view, blocks any congressional investigation. Set aside the demerits of that argument, for which I refer you to the lawyers' letters I added to the record in my previous speech and my own takedown of that argument. Sound or unsound, the point is, it is their argument in that ongoing dispute. And in that ongoing dispute, Justice Alito's Wall Street Journal comments prop up that argument. The language is nearly identical. You can compare it for yourself. In fact, lawyers for some of the billionaires to whom we have sent information requests have actually quoted Justice Alito's comment in declining to respond. So this is not just some improper general opining. It's a Supreme Court justice leaning into one side of a specific ongoing dispute and being used and quoted by one side of a specific ongoing dispute. That's pretty bad. It gets worse. One of the interviewers in that Wall Street Journal interview, attorney David Rivkin, wasn't just some interviewer. He is the attorney for a party in that specific ongoing dispute. Rivkin is the attorney making the precise legal argument that Alito echoed, and he is making it in that ongoing dispute. None of this, of course, was disclosed in the so-called interview. A logical mind would rightfully ask whether Justice Alito opined on this matter at the behest of his interviewer, attorney Rivkin. A suspicious mind would even wonder whether attorney Rivkin prepped his witness as lawyers are wont to do. With no means of fact-finding, all this remains unknown. Bad enough to opine on some general matter that may come before the court, worse when the opining brings a Supreme Court justice's influence to bear in a specific, ongoing legal dispute, and worse yet, when the influence of the justice might have been summoned by counsel to a party in that dispute. The timeline is suspicious. Mr. Rivkin's interview with Justice Alito was reportedly conducted in early July 2023. Well, on July 11th, Chairman Durbin and I had sent a letter to Rivkin's client in that dispute, inquiring about undisclosed gifts and travel provided to justices. On July 20, the Senate Judiciary Committee voted to advance my judicial ethics bill. And, by the way, the Rivkin-Alito Congress has no authority argument fared very poorly that day in the committee. On July 25th, Mr. Rivkin, by letter, refused to answer our information requests on the purported ground that, and I'm quoting him here, any attempt by Congress to enact ethics standards for the Supreme Court would falter on constitutional objections. And 3 days later, on July 28th, comes the supportive opining from Justice Alito about those constitutional objections. There are a lot of questions that need answering under oath about how this mess played out. But wait, there's more. Attorney Rivkin's client in that dispute has a relationship with Justice Alito. He is a friend, an ally of Justice Alito. Rivkin's client is Leonard Leo. Leo is not just a friend and ally of Alito. Our oversight questions that Attorney Rivkin is blocking relate to Mr. Leo's actions to facilitate gifts for Supreme Court justices from right-wing billionaires of free and undisclosed transportation and lodging. Mr. Leo didn't just facilitate, he was Justice Alito's companion on the luxurious Alaskan fishing trip in 2008 that right-wing billionaires funded. The relationship goes back. Leo's political organization, and I quote here, had run an advertising campaign supporting Alito in his confirmation fight, and Leo was reportedly part of the team that prepared Alito for his Senate hearings. So, it appears that Justice Alito, A, improperly opined in the Wall Street Journal, B, to influence a specific ongoing dispute, C, possibly at the behest of counsel in that dispute, and D, to the benefit of a personal friend and ally. None of that was disclosed in the interview either. And it brings us to the last and most damning point. Justice Alito's opining, potentially at the behest of his friend and ally's lawyer, props up an argument being used to block inquiry into undisclosed gifts and travel received by Justice Alito himself. Justice Alito himself is the ultimate beneficiary of his own improper opining. It comes full circle. In the worst case scenario, Justice Alito broke the rules against opining in order to facilitate an organized campaign to obstruct congressional investigation into tens of thousands of dollars in gifts he, Alito, personally received and doesn't want investigated. Whether Justice Alito was unwittingly used to provide fodder for such interference, or intentionally participated in that interference plan, and whether he did it to protect the right-wing billionaires, or himself, or both? Those are questions whose answers require additional facts. The heart of any due process is a fair determination of the facts. Uniquely, in the whole of government, the Supreme Court has insulated its justice from any semblance of fair fact-finding. The obstruction of our inquiries by Mr. Rivkin and Mr. Leo, fueled by Justice Alito's opining, prevents Congress from gathering those facts. And the Supreme Court won't even look. Mr. President, that can't be. Not in a nation of laws. That is flagrantly, obviously wrong. So I have asked the Chief Justice or the Judicial Conference to take whatever steps are necessary to develop a process to investigate this affair and provide the public with the prompt and trustworthy answers it deserves. The Supreme Court's legitimacy cannot stand on an edifice of obstruction, secrecy, and lies. To be continued, Mr. President. I yield the floor. And I note the absence of a quorum.
The clerk will call the roll.
Ms. Baldwin.
To capture and control our Supreme Court. We will look today at how the creepy billionaires who captured the Supreme Court get their message through to the justices that they helped plant there. That, of course, is the last leg of the capture operation. First, you have the so-called Federalist Society list, purportedly created by the Federalist Society for former President Donald Trump to pick Supreme Court justices from. Bad enough, if that were true, a secretive, anonymously funded private group picking Supreme Court justices while accepting big secret contributions? What could possibly go wrong? But it's actually worse. The Federalist Society can show no official process to cook up the list. No agenda item, no vote, no nothing. It was done in some back room, secretly, by the Federalist Society's Leonard Leo, the operative of the creepy billionaires who fund this endeavor. The Federalist Society did let Trump use the Federalist Society name for cover on the list, as if it was their list, but it wasn't. After that step, the fake list, came the billionaire-funded campaign to get the Senate to confirm the Federalist Society justices. This part of the operation ran through another dark money front group, the Judicial Crisis Network, conveniently located just down the hall in the same building on the same floor from the Federalist Society. Judicial Crisis Network is the fictitious name for yet another dark money front group. And of course, millions in dark money were poured into Senate Republican political coffers from the same billionaires. And no surprise, Republican senators voted to confirm even deeply troubled justices, and now there they sit on the court. So, let's say you're a billionaire who funded all this. You have your hand-picked justices on the Supreme Court. How are they supposed to remember what you want? Well, easy. You tell them. Cue the front groups that file briefs at the Supreme Court as amici curiae, Latin for friends of the court. They file them in coordinated flotillas, usually of about a dozen. But where it's a really big deal to the dark money billionaires, they have sent in more than 50 of these briefs. In the case where it was over 50, it was at the certiorari stage, early in the proceedings, to make sure the chosen justices got the message. That case was Americans for Prosperity Foundation versus Bonta. It was about disclosing donors behind dark money front groups. After the deluge of over 50 front group amici, the Federalist Society justices let nonprofits, known as 501c3s, hide their donors even from sovereign states where they operate and which have a responsibility to police them for fraudulent abuse of the tax system. This decision added more secrecy to the latest and greatest secret political influence technique, which is to pair a dark money 501c3 with a dark money 501c4 entity. This is, no surprise, precisely the secretive influence technique that the creepy billionaires deployed to get those chosen justices on the court. Well, we have all witnessed the sordid saga of theatrically grotesque gifts and free travel that right-wing billionaires have bestowed on certain Supreme Court justices. That is connected here. The billionaires who fund the justices' gifts and entertainment also fund front groups that come in to tell the justices what to do. So the backdrop of the capture apparatus is that billionaires choose the justices, fund the campaigns for their confirmations, and then send in flotillas of billionaire-funded front groups to give instructions. So with that backdrop, let's look at recent and coming cases and how those front groups are doing. Last term, the Federalist Society justices handed several major wins to the front groups and their backers. One of these wins came in a case called Sackett versus EPA. It was the latest assault on the EPA's power to clean up our environment and hold polluters accountable. Many of the big spending right-wing billionaires owe their fortunes to the polluting fossil fuel industry. So it's no surprise that their front groups are out to weaken the EPA. The EPA has responsibility under the Clean Water Act to make sure that our country's water remains safe and clean. Naturally, the polluters and their front groups hate this. So in Sackett, they asked the court to narrow as much as possible which waters the EPA could protect under the Clean Water Act. The front groups had their fingerprints all over this case. To start, the attorneys who brought the case came from the Pacific Legal Foundation. Because it's a dark money group, it's impossible to know exactly who funds the Pacific Legal Foundation, but in the past, it's received money from the likes of ExxonMobil, the Koch brothers political apparatus, and other groups that fund climate denial. A great many of these cases that bring in the flotillas of billionaire-funded amici are not brought up through regular litigation. They're brought by these front groups, teed up by front groups who bring in plaintiffs of convenience to bring a particular question up before the captured court. At the Supreme Court, at least 10 other far-right front group amici all urged the court to undermine the Clean Water Act. These amici included groups like the U.S. Chamber of Commerce, one of the biggest mouthpieces for the fossil fuel industry, and Americans for Prosperity Foundation, which we just spoke about, part of the Koch industry's fossil fuel political operation. I went over some of the briefs this morning in the Environment and Public Works Committee when we took a look at the Sackett case, and I'll just do a brief summary right now. The Pacific Legal Foundation has received money from Exxon, various Koch political foundations, Donors Trust, the Bradley Foundation, and the Sarah Scaife Foundation. Also in the case was Americans for Prosperity Foundation, which has been funded by the Koch political operation, Donors Trust, the Bradley Foundation, and the Sarah Scaife Foundation. And the Cato Institute was in the case, with funding by the Koch political operation, Donors Capital, Donors Trust, and the Bradley Foundation. And something called the Claremont Institute Center for Constitutional Jurisprudence chimed in with funding from Donors Capital, Donors Trust, the Bradley Foundation, and the Sarah Scaife Foundation. Liberty Justice Center came in with funding from Donors Trust and the Bradley Foundation. NFIB Small Business Legal Center came in with funding from Donors Capital, Donors Trust, and the Bradley Foundation. Atlantic Legal Foundation came in with funding from Bradley Foundation and the Sarah Scaife Foundation. Mountain States Legal Foundation came in with funding from the Koch political operation, Donors Trust, Donors Capital, the Bradley Foundation, and the Sarah Scaife Foundation. Southeastern Legal Foundation came in with funding from Donors Trust, Bradley Foundation, and Sarah Scaife Foundation, and the Washington Legal Foundation came in with funding from the Koch political operation, Donors Capital, Donors Trust, the Bradley Foundation, and the Sarah Scaife Foundation. So the litigant and 9 amici were all funded by the Kochs, by Donors Trust and Donors Capital, and the Bradley Foundation and the Scaife Foundation. They could just as easily have filed briefs in the name of the Koch political operation, Donors Trust and Donors Capital, and the Bradley Foundation and the Sarah Scaife Foundation, or even filed one brief filed by all of those entities. But instead, they created this fake machinery of front groups, creating the illusion of multiplicity and the illusion of independence, when in fact, these things are played like piano keys on a piano. And by the way, if they'd actually tried to file a brief in the name of Donors Trust and Donors Capital, it would have been a little bit weird because those are not entities that have any real role in the world other than to scrub the identities off of dark money donations to right-wing groups. So if you don't want your name on an expenditure, you give it to Donors Capital, they then pass it on to the group reports that they got it from Donors Capital, and you get to walk away hands-free without any attribution or accountability. So not only are these multiple players, they tend to switch around in this scheme. So let me add that Americans for Prosperity Foundation was the petitioner in the case with the 50-plus dark money amici that came in. There, the scheme was to get the chosen justices to protect dark money for 501c3s, and needless to say, it worked. But back to Sackett. 5 of the 6 Republican-appointed justices got the message sent by these front groups and adopted the narrowest interpretation of the Clean Water Act that they could get away with. Millions of acres of wetlands are no longer protected by the EPA. Another win for polluter interests, another loss for the American people, another successful direction by a right-wing, dark money front group flotilla. Sackett wasn't the only case where the creepy billionaires scored big at the court last term. Another win came in the student loans case, where the Federalist Society justices threw out President Biden's plan to cancel student loan debt for millions of struggling borrowers. Showing up in that case was another double-digit flotilla of far-right and industry-funded front group amici, with customary repeat players like the Koch's Americans for Prosperity Foundation, the Chamber of Commerce, and the Buckeye Institute. In this scheme, even the front groups have front groups. So Leonard Leo's Judicial Crisis Network is actually the fictitious name of another front group called the Concord Fund. And the Judicial Crisis Network, which is the same group that Leo used to help confirm the hand-picked justices, in turn propped up a new front group led by Mike Pence, funding it with more than $1 million. So the front group filed a brief in the student loans case. You cannot make this stuff up. Well, naturally, the Federalist Society justices delivered what these groups were asking for on behalf of their billionaire benefactors. But the real victory for the front group amici in this case was how the justices struck down the plan. The Federalist Society justices relied on something called the major questions doctrine, a doctrine they first deployed 2 years ago at the behest of fossil fuel groups in a case called West Virginia versus EPA. The basic idea is that if a judge thinks an agency regulation is too big or too important, the judge gets to strike it down. It's the perfect tool for billionaires to use billionaire-picked justices rather than agency subject matter expertise to stop regulations they don't like. A whole separate scheme speech could be devoted to the hothouse doctrine factories in which notions like the so-called major questions doctrine are seeded, fertilized, watered, and grown. In West Virginia versus EPA and in the student loans case, the Federalist Society justices took the doctrine from dark money funded hothouses like the Federalist Society itself and replanted it into American law. It is now law. The front groups, of course, with that opening, then began challenging even more regulations, left and right, using this supposed doctrine. And no surprise, the agency they've targeted most is the EPA. That brings me to the pending wave of front group action at the Supreme Court. One case that's received a lot of attention is Moore versus United States. That case centers on a narrow legal issue related to the Republicans' 2017 tax cuts for the rich. But the billionaires' front groups want far more. They want the chosen justices to shield the billionaire elite from paying taxes by preemptively declaring unconstitutional taxes that would more directly target the billionaires' massive fortunes. Well, given what a boon that would be for the creepy billionaires, as you can imagine, the amicus flotilla is out in full force. At least 14 far-right billionaire front groups have surfaced in Moore. And like in Sackett, a front group is litigating the case. The Competitive Enterprise Institute, it's called, which has a long history of right-wing billionaire funding. One side note about this case, remember when I said there was overlap between the right-wing billionaires who fund these groups and the right-wing billionaires who lavished Justice Thomas and Alito with luxury gifts? This case is Exhibit A, with multiple right-wing front groups funded by billionaires Paul Singer, Harlan Crow, and the Kochs, who are billionaires at the center of the ethics mess of secret freebies for certain justices at the court. It actually gets worse. In Moore, the lawyer litigating on behalf of the billionaire's cause is the same lawyer who conducted the so-called interview with Justice Alito in the Wall Street Journal editorial page about my Supreme Court ethics bill and our Senate investigations on judiciary and finance into the undisclosed gifts to certain justices. That interview propped up for the lawyer's client, Leonard Leo, the argument that we could not investigate gifts Leo orchestrated to Justice Alito. You need a diagram. You cannot make this stuff up. Litigant in Moore, lawyer to Leo, interviewer of Alito, that's a whole lot of hats for that one lawyer's head. The more you look at this operation, the more you see it as a big shell game with multiple front groups that can be moved around and multiple operatives switching around to deliver results for this billionaire elite. It's a scheme. Another case the billionaires are targeting this term is Loper Bright Enterprises versus Raimondo, with, another attack on the basic foundations of agency regulation. It's not enough that their homebrewed major questions doctrine has just been made law by their chosen justices. They want more. And of course, a flotilla of front group amici has been marshaled to urge on the Federalist Society justices. I filed a brief in that case with several colleagues documenting these amici's industry connections. Many have received hundreds of thousands, even millions of dollars from far-right and polluter interests that would benefit from weaker regulations. As usual, they are repeat performers who show up in case after case to feed the court arguments propagated in right-wing hothouses. That's the court capture process. Billionaire-funded groups cook up legal theories to help the billionaires, billionaire-funded litigation propped up by billionaire-funded flotillas of front groups, tease up the justices to adopt the hothouse theory. And then, after the justices adopt the hothouse theory, the front groups bring more cases to attack more regulations. Rinse and repeat until you've tied up or knocked down every regulation in your polluting way. As with a lot of the mess at the Supreme Court right now, the justices could do a lot to clean this up by themselves. They could require real disclosure of who is behind these flotillas of phony front groups. They could turn away cases that look like faux litigation brought by political front groups behind plaintiffs of convenience. They could adopt ethics procedures that allowed basic fact-finding into the swampy mess of billionaires, front groups, free secret gifts, and the ubiquitous fixer, Leonard Leo. And of course, they could stop granting the front group's wishes time after time after time. A new term of court presents a new opportunity for the court to recommit itself to deciding law and not just doing the bidding of creepy billionaires and their phony front groups. We too often fixate on the awful decisions that have come out of this Federalist Society majority. When we do, we overlook the nasty little web of front groups lurking behind those awful decisions. But the front group web is an important part of the story, an essential element of the court capture apparatus, and a key element of the scheme. The web should not be allowed to hide in plain view simply because we don't bother to keep track and connect the dots. To be continued. I yield the floor.